This podcast is brought to you by the School of Advanced Study, University of London. All of our podcasts are available from our website, www.sas.ac.uk.
Okay, ladies and gentlemen, I'm very, very pleased this evening to welcome our extremely distinguished speaker, Professor Deborah Anker, who joins us today all the way from Harvard in the US. I'm sure she needs very little in the way of introduction. Nonetheless, I'll say a few very brief words of presentation. Deborah is a clinical professor of law at the Harvard Law School, obviously a renowned law school in the United States, and director for 30 years of the Harvard Immigration and Refugee Clinic. In this time, she's represented through the clinic large numbers of asylum seekers in the United States system, as well as writing on the issues involved, particularly through the famous work now in its 5th edition, The Law of Asylum in the United States, published through Thompson West, for those of you who are interested in investing. Teaching students at Harvard through the clinical work of the unit itself, and the clinic itself through the work particularly of Deborah as being one of the leaders in developing the jurisprudence around asylum in the United States. And for that reason, we're particularly fortunate that Deborah's chosen to address us on this topic of legal change from the bottom up, the development of gender asylum jurisprudence in the United States. Now, Deborah's going to be speaking for a while. She has a prepared presentation. After that, we'll open to the floor for questions, comments, and discussion. So, over to you, Deborah.
If I seem to go too long, just let me know, and I'll just stop in the middle of my sentence. But thank you so much for giving me the chance to be here and exchange ideas and see old friends, new friends. So international refugee law has transformed over the past 30 years. Gender asylum has been a beneficiary of this change, but also a major catalyst for it. Thus, the recognition of gender-based asylum claims has not only had an extraordinary effect on women refugee claimants, but it has also transformed refugee law, both in the United States and among other states parties to the 51 Convention. When we think of legal change, we usually think of change from the top down, changes that result from high court decisions or new statutes. But gender asylum tells a different story. In the United States, the recognition of gender-based asylum claims originated principally in relatively non-normative instruments, including gender asylum guidelines, policy guidance, training materials, and decisions by low-level adjudicators. Change came from the bottom up. For many years, the harms faced by women went unrecognized in U.S. asylum law, until our clinic, working in collaboration with other advocates in the U.S. and internationally, pushed forward the development of the law. At our clinic, we represent women seeking asylum from all over the world, including Honduras, Guatemala, Lebanon, Zimbabwe, Kenya, Guinea, Afghanistan, to name just a few. They've often suffered serious harm such as domestic violence, female genital mutilation, threats, detention, psychological harm, rape, and torture. The human rights paradigm that the refugee definition must be analyzed in light of human rights norms provided a critical framework for recognition of the harm suffered by female asylum applicants. And asylum jurisprudence and international human rights law evolved in part as a result of advocacy in gender asylum cases. By bringing cases and presenting arguments grounded in traditionally non-normative sources, we changed the thinking of adjudicators in relevant institutional cultures, laying the foundation for changes at higher administrative and federal court levels. So today I'm first going to give you a brief overview of refugee law, U.S. implementation of the Refugee Convention and 67 Protocol, and protections for women under the Convention. Next, I'll focus on how gender asylum law has developed in the U.S. over the past 20 years, again, from the bottom up. I will look at how gender asylum cases help transform U.S. asylum law and adjudicators' understanding of key issues such as the role of non-state actors, the failure of state protection, the meaning of persecution, and the nexus and causal linkage requirement. As a result of our and others, including grassroots advocacy, the U.S. ended up playing a leadership role in the development of gender asylum jurisprudence, beginning with our Board of Immigration Appeals decision in matter of ACOSTA and our issuance of gender asylum guidelines. I'll conclude by examining how institutions and adjudicators have changed due to our advocacy from the bottom up, and will provide a few examples of recent gender asylum case victories. So, a little bit of background, which I think you probably don't know, but I'll do it quickly. So refugee status, of course, is governed by the 51 Convention and the 67 Protocol relating to the status of refugee. Two articles that are centerpieces of the Convention are Article 1 and 33. Article 1 defines a refugee, you know that definition, and Article 33 forbids a state from returning a refugee to the frontiers of a country where they may face persecution on account of one of the 5 grounds in the refugee definition: race, religion, nationality, membership of a particular social group, or political opinion. International refugee law was formulated to serve as a backup to the basic protection owed a national by his or her state. Contemporary international refugee law, having a significant pre-World War II history, arose out of the same post-World War II context that produced the major instruments of international human rights law, most fundamentally the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and these are now, we believe, properly supplemented by the Convention on the Elimination of Racial Discrimination, the Convention on the Elimination of Discrimination Against Women, and the Convention on the Rights of the Child. Refugee law provides surrogate protection when a state has failed to protect the basic human rights of its inhabitants for a discriminatory reason. Under the Convention, race, religion, nationality, membership in a particular social group, or political opinion. International refugee law is an unusual area of international law and international human rights law in that states fulfill their obligations domestically, in many cases through domestic legal systems. There's no international agency or specific treaty-based agency responsible for the implementation and interpretation of refugee law. This structure has been subject to a great deal of legitimate criticism, but the state-based implementation is in many respects a strength of the system, because enforcement is by states and provides actual remedies for people facing human rights abuses. The United States ratified the 67 Protocol to the Refugee Convention in 1968, and then in 1980 enacted specific statutory measures implementing Articles 1 and 33, replacing a former Cold War definition of refugee with the more neutral, non-ideological definition from the Protocol and Convention. The key provisions of the U.S. statute, with some exceptions, faithfully track the language of the international treaty. However, the definition of refugee in the Refugee Convention, in contrast to the definition of refugee in the Refugee Convention, the refugee definition in the U.S. context is explicitly framed in terms of persecution or well-founded fear of persecution. The U.S. statute thus adds past persecution as a separate basis for eligibility, distinct from well-founded fear. This statutory mandate is not followed entirely, as in the regulations, past persecution creates a presumption, a strong presumption, of future persecution, which can only be rebutted if the government can show either changed country conditions or that the applicant can relocate internally. The U.S. is also unusual in that the standard of risk is different in withholding an asylum in Article 33 and Article 1. The latter, asylum, also leads to permanent residency and creates a path to U.S. citizenship. This U.S. differentiation between the standard of risk in asylum and withholding, or Article 1 and Article 33, has been the subject to much international criticism, and I can go into it more during the question period if there is interest. As I mentioned, women may seek asylum or refugee protection for a wide range of reasons. They may flee a range of human rights violations, some of which relate directly to their gender. They flee, among other harms, sexual assault, domestic violence, forced prostitution, forced marriage, female genital mutilation, substantial or severe economic harm, torture, detention, threats, emotional and psychological harm, violation of their religious or political beliefs, and feminist opinions. Gender asylum claims may be based on any number of grounds, include any of the grounds under the Refugee Convention, under the refugee definition in the Convention. Some argue that it is a problem that gender is not an explicit ground in the definition, but beyond the instrumental reason that it would be impossible to get the convention amended in any progressive direction at this time, this argument fails to account for the fact that gender, properly understood and accounted for, should pervade the interpretation of every element of the refugee definition. The obstacles to women's eligibility for refugee status lie not in the legal categories per se, i.e. the non-inclusion of gender or sex as one of the 5 grounds, but in the incomplete and gendered interpretation of refugee law. The failure of decision makers to, in Helen Crowley's words, acknowledge and respond to the gendering of politics and of women's relationship to the state. Simply adding gender or sex to the enumerated grounds of persecution would not solve this problem, nor would it address cases such as those in the interpretation of the persecution element where the harm feared was unique to or disproportionately affects women. As I will discuss, gender asylum has transformed our understanding of each of the elements of the refugee definition. For example, as to the element of persecution, 20 years ago, refugee law, like international law, was so trapped within the public-private distinction, with harms disproportionately affecting women relegated to the private sphere, that rape was not generally understood as cognizable harm amounting to persecution. Refugee law has come a long way since then, and it's now well established that rape constitutes persecution, and that refugee law provides surrogate protection to those who have suffered or fear harm by private, non-governmental actors. When harm is inflicted by non-state actors, for example, in cases involving domestic violence, adjudicators now recognize that in many countries seeking state protection is futile and indeed could result in further persecution. Showing that a victim has tried to seek protection is not therefore required of applicants, especially where it can be shown that the state supports gender stereotypes or turns a blind eye to intimate partner violence, or even where the state pays lip service to trying to change how women are treated, but in reality does not have the power, the resources, or the will to effect this change. For example, from one of our cases, Honduras has passed anti-domestic violence laws and set up special domestic violence courts, but in practice there are no real safeguards for survivors of domestic violence. Our client, Imelda's mother, called the police once and they picked the abuser up and let him go just a few blocks away. Imelda never called the police because she knew it was futile and even dangerous, and asylum law should not require any more than that. With respect to the nexus or causation element, increasingly adjudicators in the U.S. do not require that the applicant prove the subjective intent or malice of an individual persecutor. Instead, applicants can point to the effect or results of the persecution to demonstrate nexus. For example, again taken from our cases, FGM and forced marriage in Guinea are considered part of the tradition and culture, but the fact that girls are subjected to these practices by family and tribal members with a benign intent does not matter. It is still persecution on account of their gender-based particular social group membership. Persecution must be assessed under an objective standard. As to the grounds, which I'll discuss further, gender-based cases have promoted a conceptualization of the particular social group ground based on non-discriminatory protections of international law. Gender asylum has also led to the development and flowering of the political opinion ground, expanding adjudicators' understandings of political opinion to include feminist opinions, women's opinions about equal rights and equal treatment, and non-traditional arenas for expression of political opinion, including supplying food and shelter to members of dissident guerrilla or political movements. Gender-based cases have also helped shape our understanding of the bars to asylum in U.S. law, promoting, for example, more generous interpretations of exceptions to our one-year filing deadline. Since many women are too terrified to reveal that they have suffered and hide in the U.S. for years before coming forward, they are subject to the one-year filing deadline bar unless they meet an exception. Exceptions to the one-year bar include mental or physical disabilities, including post-traumatic stress disorder or PTSD, which prevent the applicant from coming forward earlier and also change country conditions. These are just a few examples of the ways in which gender asylum has catalyzed a transformation of U.S. asylum law. Gender asylum cases have led to expanded recognition of emotional and psychological harm, economic and social rights violations as persecution in asylum cases, as well as increased recognition of claims brought by children and family members, as well as other types of claims. Thus, gender cases set the stage for a consideration of deeper social context, and refugee law generally has matured as a result. Before I give you a historical overview of the positive, substantive, and procedural changes over the past 20 years that have greatly improved the treatment of women seeking asylum in the U.S., I want to emphasize an important point regarding the character of decision-making in immigration cases, especially relevant in the gender asylum context. Most asylum cases that are won in the U.S. do not result in written opinions, and so while, for example, gender claims are succeeding on a daily basis, they are based on and result in changes in the law that are not always visible or formalized. An important strategy has been to exploit this informal realm that we argue should be highly normative. After all, it is the legal change that is actually happening on a case-by-case basis. Our asylum office doesn't write publicly available decisions, and immigration judges, these are the first-tier decision makers, often give oral decisions, and even if they issue written decision, it is rare for them to be circulated. None of these decisions is precedential. Cases that trickle up to the federal court level are often based on poorly developed facts or a bad record. Poor decision-making by the board and immigration judges is often upheld as a matter of deference, so it is often the weak and poorly developed cases that are formalized to create the visible legal precedents. Even so, often you'll see an article in the front page of the newspaper, at least the New York Times, U.S. newspaper, talking about gender asylum as this new expanded form of protection for women who suffer domestic violence and whose home countries can't or won't protect them. But gender asylum is not an expansion of the law, just an appeal to fair and equal treatment of women refugees. We have created the law out of sources you wouldn't normally consider legitimate or law-like. We've gone outside the traditional framework of published federal court and board decisions to argue for and win our cases, drawing on unpublished decisions and sub-regulatory sources, which has resulted in these sources being treated in a more formalized manner. Thus, gender asylum has evolved in an unusual manner, given how salient sub-regulatory sources are in the shaping of doctrine and norms. We have successfully argued for the normative effect of the sub-regulatory. These include UNHCR gender guidelines and national gender guidelines, which I'll discuss further, as well as training materials from the USCIS Asylum Office, which digest and analyze the law and take often progressive positions, especially on gender asylum, children's cases, and related claims. We have participated actively in the training of asylum officers and indirectly in the development of their training materials. Unpublished Board of Immigration Appeals decisions, administrative appellate decisions, immigration judge, first-tier decision-maker decisions, and government briefs are part of the law, and we argue and win at the federal circuit court level and submit amicus briefs based on these sources. We argue that these decisions and briefs represent agency practice. Formal changes in the law are slow to emerge. In the meantime, we keep bringing cases at the individual hearing level, which has led to significant institutional changes on how claims are treated by immigration judges and government trial attorneys. The law isn't always the formal law in the book. Part of our advocacy has been to create this sub-formal law and then to argue its normative effect. Now I'll go through a little bit of the history. The foundation for our current understanding of a particular social group as embracing gender is based on a Board of Immigration Appeals 1985 decision in matter of Acosta, which defines a particular social group in an immutability framework. Acosta was not only the foundational case in the U.S., but also internationally. In Acosta, the board specifically named sex as a quintessential immutable characteristic, but until the advocacy around gender asylum, the board did not even pay lip service to this reasoning. The board in Acosta stated, "We interpret the phrase persecution on account of membership in a particular social group to mean persecution that is directed toward an individual who is a member of a group of persons, all of whom share a common immutable characteristic. The shared characteristic might be an innate one, such as sex, color, or kinship ties, or in some circumstances it might be former military leadership or land ownership. Whatever the common characteristic that defines the groups, it must be one that members of the group either cannot change or should not be required to change because it is fundamental to their individual identities or consciences. End quote. The UNHCR Executive Committee also, in 1985, the same year as ACOSTA was issued, also set the stage for the development of gender asylum law when it adopted conclusion number 391993, recognizing that states are free to adopt the interpretation that women asylum seekers who face harsh or inhuman treatment due to their having transgressed social mores of the society in which they live may be considered a particular social group under the convention. Following ACOSTA and this UNHCR Executive Committee conclusion, we argued that immutable characteristics include sex, and therefore gender should define a particular social group. The international women's rights movement has taught us that the only way to include women in any human rights framework was to challenge the public-private distinction, to recognize that harms committed by private actors or human rights violations and harms committed against women in the private sphere were of public concern and should be considered serious human rights violations embraced within the Refugee Convention's persecution standard. In the late 80s and early 90s, advocacy efforts, including collaboration across borders between women's human rights activists, immigration rights activists, advocates, and scholars, led to positive changes. Along with our grassroots legal services organization and part of Greater Boston Legal Services, we founded the Women's Refugee Project to advocate for a gender-sensitive interpretation of refugee law. Refugee advocacy and scholarship in the late 80s and 90s grounded itself in international human rights law, including the core human rights treaties I mentioned before, and advocacy that grew out of the 1995 Beijing Women's Conference and other international collaborations, specifically our work with Canadian and other advocates around the world to push for refugee women's rights. The human rights paradigm and the leadership of UNHCR in dialogue with NGOs and civil society provided the critical backdrop for the development of gender asylum jurisprudence. Gender asylum needed the human rights paradigm, and international human rights law evolved in part as a result of our advocacy for gender asylum. For example, in the landmark 1993 case of Canada versus Ward, the Supreme Court of Canada stated that, quote, underlying the Refugee Convention is the international community's commitment to the assurance of basic human rights without discrimination. Persecution, for example, undefined in the Convention, has been ascribed the meaning of sustained or systematic violation of basic human rights, demonstrative of a failure of state protection. During this period in the early 1990s, our clinic and other asylum and refugee lawyers advocated tirelessly for U.S. and international tribunals and courts to recognize gender violence as persecution and feminism as a political opinion. In 1993, Canada issued its historic gender asylum guidelines, which served as a model for U.S. advocates and advocates around the world. At the time, our clinic was deeply enmeshed in representing asylum seekers in individual asylum proceedings. And when Haitians first started fleeing to the U.S. following the first coup against President Aristide in 1993, we represented them. Among our clients were Haitian women, and they told stories that clearly revealed the changed nature of the harm they had suffered and faced in Haiti. When the Board of Immigration Appeals, again that's our administrative appellate body, issued a decision in the case of DV in 1993, granting asylum to a Haitian woman who had been gang raped and beaten in her home by members of the Haitian military because of her support for President Aristide. The decision was initially hidden, not published as precedent. And we argued, organizing together with other immigration professors and law clinics, we argued successfully to have the DV's decision established as a precedent administrative decision. At the same time, our clinic began to consult with and write amicus briefs on gender asylum, including in the Third Circuit case of Fatine, which recognized that feminism could constitute a political opinion. The Federal Circuit Court in Fatine's decision, in addition to recognizing that gender could define a particular social group, acknowledged that persecution was, quote, broad enough to include measures that compel an individual to engage in conduct that is not physically painful or harmful, but is abhorrent to that individual's deepest beliefs, and that feminist opinions could be such beliefs. The Third Circuit's recognition of feminism as a political opinion was particularly critical, and in the years since then, advocates have often framed gender asylum claims not only in terms of the PSG ground, but also in terms of feminist political opinions. In 1995, our clinic joined with the Center for Constitutional Rights to interview and gather affidavits from women in Haiti and who had fled Haiti, who were being systematically raped and beaten in retaliation for their actual and presumed political beliefs. We submitted a report to the Inter-American Commission on Human Rights, which then recognized that rape constitutes torture, even outside of the state detention context. This was the first recognition of rape as torture by an international human rights body. Through our proactive advocacy and collaboration across the border with advocates in Canada, as well as with interested U.S. non-governmental organizations and government officials, we succeeded in getting the U.S. to issue gender asylum guidelines in 1995. Before the guidelines were issued, several articles appeared in the national media on gender asylum. We worked with female journalists to highlight the fairness and equity issues at stake, and the New York Times and other major newspapers ran front-page articles and in-depth newspaper magazine articles highlighting the individual stories of women seeking asylum because of gender-based persecution or because of their gender. Our clinic drafted the gender guidelines, which incorporated human rights standards and addressed both procedural and substantive aspects of adjudication of women's claims. The U.S. was a leader in issuing gender guidelines, the second country to issue guidelines after Canada, which as noted, issued the first guidelines in 1993. Although these guidelines were sub-regulatory pronouncements by the U.S. government, the guidelines, in part because of how they were portrayed by us and other advocates, became highly normative and influential. A published board decision in 1996, matter of Kasinga, recognized FGM, female genital mutilation, as a basis for an asylum claim. The 1996 decision involved the case of a young woman from Togo who feared FGM, and the PSG constructed was problematically circular. Young women of the Chamba Kusuntu tribe who had not had FGM practiced by that tribe and who opposed the practice. The PSG folded together two grounds, the PSG ground of political opinion, i.e. opposing the practice, as well as the risk factor, well-founded fear, an entirely different element of the refugee definition. In her concurrence, board member Lori Rosenberg argued against this construction and for a PSG based on a single immutable characteristic, in this case, Kasinga's gender. This is the principal formulation that we've advocated for our work, that gender itself should define a particular social group. But since Kasinga, PSGs in gender-based cases are too often constructed as gender plus some other factor, such as victimization, the harm suffered, or another ground, i.e. political opinion. This has been a clear problem in gender cases, the failure to recognize that gender itself can define a particular social group, that women or women of a given tribe or nationality can constitute a particular social group. And these problematically constructed particular social groups, PSGs I'll call them, have had a negative effect on the formulation of PSGs in other contexts, and really stymied the development of U.S. asylum law in many respects, which I can go into later. Our clinic has been at the forefront of pushing for the recognition of gender as the relevant PSG in these cases, by publishing articles, writing amicus briefs, training asylum officers, and bringing cases in which gender is the PSG. At the same time, we've also developed the argument, building on 15, that feminism can constitute a political opinion, and feminism includes resistance to such practices as FGM and domestic violence. In the late 1990s and early 2000s, courts around the world, including the UK House of Lords and Shah and Islam, and later the Australian High Court in a case called Kawar, issued gender decisions focusing on the failure of state protection and its role in asylum law, and the non-state actor doctrine and the recognition of the bifurcated nature of persecution, i.e. that persecution involves two prongs, serious harm plus failure of state protection. In Shah and Islam, the House of Lords considered how broader patterns of discriminatory treatment of women in Pakistan structurally enabled the specific violence the applicants feared from their husbands. In Refugee Appeal Number, this is how New Zealand does it, 71427, the New Zealand authorities in 1999 analyzed in detail state patterns in Iran that condoned family violence and discriminated against women, even where the state constitution did not formally relegate women to second-class status. In Minister of Immigration and Multicultural Affairs versus Kawar, the High Court of Australia found evidence of Pakistani state acquiescence in discriminatory enforcement of the law, a deliberate failure of the police to respond to a woman's complaints of her husband's violence. Then a lightning rod case in 1999, the matter of RA, hit the American press and complicated the landscape. The board denied asylum to a Guatemalan woman fleeing a very violently abusive relationship. In 2001, our Attorney General Reno vacated the decision on the last day of her term and sent it back to the board to decide in light of regulations that still have not been issued. The case was rebriefed to the board in 2004, and almost 200 groups, 187 to be exact, and individuals and organizations signed on to our clinic's amicus brief. The brief submitted by the Department of Homeland Security, which is the new immigration agency which was formed in 2002 in the U.S., recommended an asylum grant to the applicant in RA and defined PSG as married women who were unable to leave the relationship. From our perspective, this PSG was close. It was not quite right, but close. In 2005, another Attorney General under the Bush administration, Attorney General Ashcroft, attempted to revive RA by reasserting jurisdiction over it, but he too sent it back to the board, where the case festered for years with no decision as to whether domestic violence could form the basis of an asylum claim, and with no recognition from the board that gender itself defines a PSG in these cases. For 10 years, while RA was left undecided, we kept bringing many individual cases based on both gender as a PSG and feminism as a political opinion, among other grounds. We used the DHS brief in RA to argue for the Department of Homeland Security brief in RA to argue for grants for our clients based on PSG. The DSH brief was the strongest, non-traditional, but we argued highly normative instrument we had. We argued that the position articulated by DHS reflected the government's understanding of PSG, was an expression of agency policy, and asked adjudicators to adopt this understanding. Meanwhile, renegades within DHS discounted the brief and argued that it was not the authoritative or binding and could not be submitted as evidence. The DHS brief had been the result of a struggle between enforcement and protection advocates within DHS. And I can tell more of that story if we have time. Well, yet there was a standstill at a formal level. We were winning these cases and helping to shape the development of the law at lower levels, in front of the asylum office and before immigration judges. While the issue of gender as a PSG was on hold because of RA, we focused on developing the political opinion theory in domestic violence cases in parallel. Decision makers at the lower levels increasingly recognized that resistance to domestic violence through refusal to follow the spouse's orders, through attempts to escape and ultimately flight, constituted the expression of a political opinion. We worked with our clients to elicit their opinions about how they believed they should be treated, and to elicit information about how they express these opinions in their relationships and the consequences they face of them. Our colleagues at GBLS, Greater Boston Legal Services, described this as the independent woman case theory, which reflected more generally conflicts and changes regarding the position of women in Latin America, for example. As one client explained in her affidavit, quote, "I am an independent and successful businesswoman, and I've always believed that women should be treated equally and with respect. But Yeltsin hated my independence, my self-sufficiency, and my success. He considered me his property and could not stand that I refused to submit to him. He attacked me for working hard, for educating and improving myself, and for standing up for myself. He demanded that I stop working, but I was proud of my work, and told him over and over that I would not quit. I told him that I had my own life, I could provide for myself and my family. The greater success I had in my work, the angrier and more violent Yeltsin became." As we brought more and more of these claims, adjudicators increasingly started recognizing their political nature, and we saw the political opinion ground develop to include women's belief in equal treatment and opposition to domestic violence. The difficulty with gender as a PSG led to the flowering of the political opinion ground. The holding pattern that was created by the withholding of the decision in RA created the opportunity for the development of this independent woman political opinion case theory. Finally, in 2009, the board quietly remanded the case of RA to the immigration judge, who was instructed to grant asylum, but again without a decision in the case that was precedential. Indeed, we were left simply with the fact that the case was granted, but no exposition of theory, no explanation for its grant. That same year, a similar case, LR, was decided and hit the front pages of prominent newspapers again, including the New York Times, and the DHS brief was again critical. Department of Homeland Security brief in LR defined PSG in terms of Mexican women in domestic relationships who were unable to leave, and Mexican women who refused property by virtue of their position within a domestic relationship, and recommended an asylum grant. The case was remanded and the IJ granted asylum in 2010, but again without a written or precedential decision. Advocates who had long used the DHS brief in RA also started using the brief in LR in court to argue for recognition of these claims, but still faced opposition. The briefs submitted in RA and LR we used to argue that the positions taken in them are the law, that they represent agency interpretation and policy, and that the agency should be held to them. In 2010, our clinic gathered examples from across the country of the enforcement branch, ICE, it's the enforcement branch of the Department of Homeland Security. Their trial attorneys stated opposition to the LR brief in immigration court and submitted these examples to the House Subcommittee on Immigration, who then met with ICE and pushed ICE to recognize the DHS position set forth in LR. In response, we saw ICE changing the position in cases across the country, recognizing the DHS position in LR and domestic violence as the basis for an asylum case. In one case we heard of, DHS issued a written clarification which stated that, quote, DHS has always maintained that domestic violence can be the basis for asylum. The clarification was then slightly revised to state that, as a general matter, the department continues to maintain that victims of domestic violence can qualify for asylum. We sent this clarification out on our immigration law professor's listserv so that advocates and scholars could use it to support their argument in gender asylum cases. And this written clarification is now cited in the leading immigration law casebook as recognition that domestic violence is a basis for asylum, and gender defining a particular social group is now effectively the law of the land. This shows how with advocacy, even a single statement in a single case can have persuasive power in other cases and result in changing patterns of decision-making. We have won victories before asylum officers, immigration judges, and even at the board, but we have not received a solid precedential decision. In the fall of 2011 and then in 2012, the board asked us for amicus briefing on the question of whether domestic violence can be the basis of an asylum claim. We are cautiously optimistic about the board decision, at least the issuance of a moderate position, especially because the ground underneath the board and across decision makers and institutions has shifted, and asylum claims based on domestic violence are being consistently won, or I shouldn't say consistently, are being very frequently won, and case by case. And so while we're waiting, we're still winning cases. And I think time is getting short. Got 10 minutes? Okay. So Imelda, I think that's the case I already discussed. In fact, I think maybe I'll skip it. So another case, another recent case, no, I won't skip it. Most recently, a woman from Honduras who suffered extraordinary domestic violence at the hands of a police officer who raped her at age 13 and then continued to stalk her for years, kidnapping her, beating her, raping her at gunpoint, attacking her with a machete, attacking her from behind. The excerpt I read earlier describing an applicant's belief in her ability to lead an independent, successful life were taken from her case. Her client hated the abuser. She never loved him and never wanted a relationship with him. She didn't want to be subservient of him. She didn't want to be with him. She wanted to be independent and lead her own life. She was a successful manager at a local retail chain, and as she became more and more successful in her work, his attacks became worse and worse. After suffering over a decade of violence when she couldn't take it any longer, she managed to flee to the United States. But even after arriving here, she was so traumatized that she was unable to come forward and talk about what she'd been through. 8 years after her arrival, she applied for asylum based on gender as a particular social group and her feminist political opinions, and she won. Another recent case involved a woman from Zimbabwe who had also been in the U.S. since the early 2000s when she fled her abusive husband in Zimbabwe. For years, she had been too scared to tell anyone about what she'd suffered back home. She'd been very depressed and living in hiding in the U.S. When we asked her what her political beliefs were, she said she was not political. Over time, working with her, we learned that she had very strong feminist beliefs about how women should be treated, based on having seen her parents treat each other respectfully and her brothers as equals, and also because equality and human rights were part of her church's teaching. As we met more with her, we also learned that her husband worked as a driver for the equivalent of the Department of Education and was a strong supporter of President Mugabe, while she was against President Mugabe, and especially against his inhumane treatment of people and the lack of freedom throughout the country. When she stood up to her husband, it made him even angrier. He tried to stop her from working, but she refused. She also secretly gave money to the main opposition party behind his back. But she was too scared to tell us that for a long time because of fear of Mugabe spies even here in the U.S. We try to develop our claims based on multiple grounds so adjudicators can choose the one they are most comfortable with. Feminist opinions, race, religion, PSGs are often in place. In Sari's case, based on feminist political opinions, her support of the opposition party, both of these fitting under the political opinion ground, and her gendered particular social group. In both of these cases, the one-year filing deadline was a significant challenge, but we were able to work closely with psychologists who were able to help treat our clients for PTSD, and were able post-traumatic stress disorder, and were able to write an evaluation showing that the trauma they experienced as a result of years of violence at the hands of their abusers had prevented them from coming forward, which fit the extraordinary circumstances exception to our law's one-year filing deadline. So just a couple of things in closing. The development of U.S. gender asylum law tells a fascinating and different story of progressive legal change. We created this change, and indeed, change is not, it's incomplete change, but we created this change by grounding the law in our advocacy and individual case representation, as well as by engaging in litigation at higher levels. The traditional story of law and legal change is one of litigation or major legislation first, but then opens the door for change at the ground level. But ours is a grounds-up story. We now have a deep tradition of recognizing gender-based persecution and gender-based asylum claims, and this transformation of the law was brought about by representation of individual clients, advocacy on the ground with NGOs, people in government, and women in the media, who highlighted the issues of fairness and equality central to gender asylum claims, successfully representing women in gender asylum claims. Gender asylum isn't the only evolving area of law that our clinic has been working actively in shaping. Our advocacy around gender asylum has set the stage for other evolving areas of law, including the recognition of economic and social rights violations as persecution, the increased salience of psychological and emotional harm, as well as the heightened awareness of the need for special consideration of claims brought by children. So I think I fit just in my 40 minutes, or 45.
Very good. Yes, exactly. So, thank you very much.
You're welcome.
Whilst listening to the talk, I mean, it occurs to me, not only what an inspirational story this is, in spite of, as you say, still some distance to travel, but also one thinks a little bit about the particularities, perhaps, of the US situation in terms of the way that it relates to asylum, and particularly the way that its law is set up. And I suspect that we may have, or I'd like to invite, comments. I know we've got some quite senior legal practitioners in the room, and whether there are analogies between the US case and the way that gender asylum jurisprudence is developed in the UK, which, based on my experience, sounds somewhat different. But just before I open the floor to comments, I had a couple of questions, which you're very welcome to answer once we've taken other comments from the floor. And one of those was, it seems very clear that in the United States, along with the work of your clinic and absolutely, along with the work of your clinic and others in the field, that there's been quite a strong degree of pressure from sort of extra legal sources, you know, the use of the media and others. And I wonder to what extent that's been useful or helpful in creating a political context whereby these decisions receive increasing recognition. And one might think that in the UK, perhaps, though that receptivity to these sorts of cases may or may not be here. The other thing that I wondered is, you know, your talk focused very much on the issue of domestic factors pushing this jurisprudence at the lower levels particularly. Has there been influence, I mean, do US courts look overseas? Do they look to decisions such as war and gain inspiration also there from those sorts of sources? And I suppose finally, you've talked about how the field's developed, and given your unique standpoint of working on these cases over the last 20, 30 years, where do you think the jurisprudence will go in the next 20 years in the US? Where are the battles to be fought? So those are some questions, I guess, to come back to. But I'd like to open up to comments from others here in the audience, and particularly UK practitioners, who I'm sure have a much better sense than I do about what's happening in this field here. May wish to offer some comments on this.
Well, first of all, I notice a sense of frustration as a lawyer that you don't have these written decisions and this development of precedent, because I think I've been knocking my head against a brick wall in that sort of scenario. That I know that there are murmurings, firstly a tribunal here in the UK, about providing oral judgments without a written decision, and I think that would be very frightening. But you know, I also note your frustration that gender doesn't stand there as a freestanding PSG ground, that you have to have some additional plus issue in relation to establishing the refugee claim. And I know in your writings on lesbian and gay cases and what's been happening internationally, that lesbian and gay individuals have been able to establish a freestanding refugee claim even in the States. But why isn't this being transferred to gender? Why is there still the schism and disparity in relation to gender as a freestanding ground of a refugee convention analysis? And the only other point is that last year, I think I remember there was some sort of debate in North America about separating the nexus requirement regarding discrimination as being separate to the persecution in PSG cases. I don't know if you're able to...
Say that one more time?
Well, I understood that last year there was some debate in North America about getting rid of the discrimination independent of the persecution in PSG cases. I don't know if you were
that
part...
doesn't ring a bell.
Okay, well, is it something
but it
which...
might be something, yeah, that just the framing of it is not... Sorry.
In relation to immutable characteristic and definition of particular social group, I understood that there was some debate about whether the discrimination needs to be there as to establish the PSG convention reason. I don't know if you...
So
you don't need the
no need
discrimination
for a convention reason?
No, you don't need the discrimination to be independent of the persecution. No, okay, well...
Sorry.
Okay, well, that's another issue. But the issue in relation to why gender can't stand by itself, and how do you think you're going to be able to change that sort of reasoning in the States?
Well, I don't know how we're going to change it. We have two separate sort of norm-producing administrative agencies. One, the Department of Homeland Security, which there was a struggle. There was an intense struggle over years between enforcement and protection elements there. And in the writing of the briefs and the argument for these cases, the protection elements have won. But they won by making a compromise, right? And the compromise is women in domestic relationships, abusive relationships who cannot leave, these kind of not terrible but convoluted social groups. And so there's been, and now we have our Board of Immigration Appeals, which is an administrative appellate body separate from the Department of Homeland Security, is now twice asked for briefing on this issue, for significant amicus briefing. And we submitted a brief representing the American Immigration Lawyers Association. So once in the fall of 2011 and once in the fall of 2012. God, I think I'm going to tell you too much about the U.S. system here, but once in 2011, once in 2012, and in both cases, DHS grabbed the cases from under them So it asked the same thing it did in RA. It asked for, we're going to grant this case and please remand it for a grant. DHS, it said, is, well, I know, DHS wants regulations and to take a regulatory as opposed to adjudicative approach. DHS has to negotiate with the Department of Justice on what the content of those regulations are. And I don't know, I feel so nervous about how those regulations may come out. I feel very nervous about how the board decision may come out. You know, people within DHS have, we've been urged to, you know, advocate for a regulatory approach, and we probably should, but I'm totally torn. Totally, what's the word when you're immobilized? Not knowing which is a bit, not that it would matter what we advocated for necessarily, but it's really hard to tell what's gonna happen. But it's either gonna come from regulations or it's gonna come from this decision in the Board of Immigration Appeals. There's one case that they still haven't remanded that remains alive. Or it's just not going to happen, and it's going to keep going on like this. Which is, there's talk we've promoted and proposed that gender defining a particular social group be put in legislation. So maybe that has some promise. There's a Refugee Protection Act, I think, that just got reintroduced into Congress. I think I just flashed my emails and saw it. And it's included there. The U.S. is considering, I mean, is this too much information? No, the U.S. is considering comprehensive immigration reform to legalize undocumented people and increase enforcement. And there's talk of including PSG, defining gender as a PSG, as legislation, as part of that legislation. So whether these things will take off, particularly the two legislative approaches, we should know very shortly. But it's been a very, frustrating 10 years, and if we hadn't been winning these cases on an individual basis and having this amazing contact with these amazing women, I don't know, I'd be a sadder person than I am today.
On that note, I'm going to open up. Yes, Carol.
Can I just follow up on that?
Sure.
I'm wondering if you think that some of the difficulty is the sort of classic fear of opening the floodgates, and that calling gender a PSG looks like you're going to let everybody, you know, it just makes the category too broad, which is why some of these PSG categories have been small, convoluted, as you put it.
Yeah, I think there is fear of floodgates. So practitioners have introduced, it's not just, you know, these convoluted social groups, so that they look like they can get an access to some narrow group of women, and then the board has come back and said, you know, that convoluted social group doesn't sound like a social group. I mean, shouldn't it be socially visible? Shouldn't it be more particular? So now we have these requirements of social visibility and particularity put on top of the cost and mutability paradigm, which is just a nightmare. It's just a real nightmare. I mean, what I say to this is, it's just, first of all, Costa said it back in 1985, then completely validated in the Ward decision in Canada. I'll get back to your question. And in Shah Islam and Kawar, that gender can define a particular social group. And look at the other grounds in that the particular social group ground should be interpreted similarly to the other grounds, and the other grounds all represent, you know, characteristics that can't be changed or shouldn't be changed because they're fundamental to individual beliefs or consciousness. And look at race. Race is a really big category. Look at nationality, really big category. So to argue that gender is a big category, it's not the category that gets you asylum. It's the category plus proof of persecution plus proof that you have a well-founded fear of persecution, and the U.S. also suffered it in the past. But you have to have all of these elements, and what this collapsing of the social group is doing is putting all those categories into all the theory of the case into the ground. as a way of getting around a principled approach of making gender a particular social group. And I have to say, more and more major advocates are coming around to gender should define a particular social group. And that was the collective. There was a gang case that was recently argued, and I argued before the Board of Immigration Appeals, and in arguing against the social visibility and social visibility and particularity requirement. I also think PSG is being overused. Now everything has to be a PSG, and often cases are political opinion. And the political opinion ground has not only been neglected in women's cases, but it's been neglected all around. So in the gang cases, it's, you have somebody who stood up to a gang or resisted a gang by fleeing. And especially when they stood up to a gang or even testified in court against a gang member, that's a political opinion. I mean, if you can't get your client to own that as a political opinion, you're just a lousy lawyer. I mean, it is a political opinion. And yet it's like becoming a social group. You have to make it into a social group. So it's, people fleeing gang violence who object to gang violence and who speak up against gang violence and who are subject to harm as a result. I mean, these social groups go on for like a page. Not a page, but a paragraph. It's terrible. And so I think, at least in the U.S., the practitioner world is partly to blame for the problem that we have.
If that's right, do you think it is because of the difficulty of getting somebody to own an individual political opinion? It's much easier to define a
No,
group
it's bad advocacy. Because I think, I think you can get a client to own it. You just have to work with them a lot and understand politics in a much more nuanced way. Yeah, you have to understand. It requires more.
Okay, Olivia and then David.
Just a small comment on this, but I mean, it's also the case that it could be imputed political opinion. In some cases, the young one is clearly one why going around and finding a PSG, but imputed political opinion is good enough.
Oh, I'm so sorry I forgot that, and thank you so much for raising it. Yeah, big. Why have we gotten in this tangle of finding everything has to be a PSG and then not properly defining PSG in terms of a single kind of immutable characteristic is, I don't know. Look through it, but can't really fully explain it.
It was very studied. David.
I was going to make the same point on imputation. If you're not for us, you're against us.
Right.
And the gang case to me sounds like a classic example. If you take yourself outside the gang, you are representing yourself as therefore opposed to the gang.
Right.
Just as if you take yourself outside a domestic violence situation, you are opposing the norm within that society.
Right. No, that's a really good point about imputed political opinion.
Eric and sorry,
Good evening.
Professor, good evening.
Good evening.
In the last 20 to 30 years, in every jurisdiction I can think of, there's been a tremendous positive development of gender consciousness in relation to the Article 1A2 elements of persecution and conventional reason. Is there a risk that one gains on those fronts, but then you lose a lot in improperly gender-based ideas about relocation that in practice discriminate against women when you get to the stage of internal relocation alternative, which is often stressed in many jurisdictions?
Can you give an example?
Yes, I mean in this country, rape cases, gang cases, the routine answer to them is you can relocate. You move to a different town. That's the standard answer to a domestic violence case in this country.
Well, UNHCR has a stand. You can't if you're not going to get protection there, right? And you can't if you're still going to be a refugee in another part of the country and your state can't protect you or fails to protect for whatever reason, you are still a refugee. And UNHCR came up with additional requirement that it should be reasonable for you to relocate in a particular country. So if you're a woman on your own, you can't just walk into a new community and establish yourself. We need the support of a community, so you can't move to a new town or a new city. So there's a whole jurisprudence, I mean, I'm sure you know it, on internal relocation. But we haven't had as much of a problem with it as one could imagine. In the case of pet, did you want to say something else?
Well,
Sorry, let's get off on a tangent.
putting it in one sentence in this jurisdiction, the approach to whether relocation is reasonable often seems quite a gendered one. And so you have quite a progressive approach on persecution and on convention reason, which then really breaks down in the approach that you can avoid most things by relocation. That it's reasonable to endure quite a high degree of...
Now, why is it reasonable for a woman to relocate in another part of the country? Why is this happening in a gendered way? How is it happening in a gendered way?
It's happening because reasonableness hasn't yet been made a structured discipline in the way persecution or convention reason has been.
Right.
So tribunals get pushed towards allowing appeals over 70 pages, and you can lose in 4 paragraphs on relocation because it's, for example, reasonable to live in a distressed women's refuge in Pakistan with your children in relocation from your violent partner. So I'm not suggesting that's right. I think it's a very serious problem.
It sounds like a serious problem. It's not a serious, particularly serious problem in the U.S. I mean, it's a problem, but it's not a big problem. That's all I can say in response. It shouldn't be, and we both know why it shouldn't be, right? Argue that way.
In terms of alternative or a different question? Sorry,
different question.
Okay. You want us to continue to answer, or?
No, it's a different point.
I was wondering, in the end, you mentioned that your work on gender as an asylum claim has had influence on children. And picking up on the discussion we had earlier, how do you, first of all, I was wondering whether you can elaborate on that, and then children as a particular social group, or children having a political opinion, which I think is, or unaccompanied minors if we use the official term. So where would you map that in that discussion?
Well, I think children can be a particular social group, and childhood lasts a long time has been the response by U.S. decision makers about it, so that it can be considered immutable even though we grow out of childhood into adults. And I think that, and we have children's asylum guidelines now. UNHCR has guidelines, if you're aware of them. And I think our guidelines are probably based a lot on, and a lot of it is procedural. A lot of it's about how you talk to kids and how you understand what they say. So, you have a kid whose family was active. This was a case we had, and we won at the appeals level ultimately, but whose family was active in the law reform, in the cooperative land cooperative movement in El Salvador. And as a result, he was attacked a lot as a kid, right? But he experienced it then as being just attacked by bullies and, other kids in the neighborhood, and didn't really completely understand why. But we talked to him about it more. We brought out the context. Sometimes the context of the political opinion comes from sources outside of the testimony of the child, right? And I know in the U.S. they found that persecution or harm is different in the case of children than it is in the case of adults. That persecution, that harm can be harm to family members is often persecution in the case of children. and it may be harm, and emotional harm is more salient in children's cases, and we have to be more aware of it and do more of the work of working with psychologists and others to get that testimony. So I think in general what gender has done is it's opened up context. You have to look at things in a contextual way to understand the way in which they're political, and to understand the way in which they're religious. And you really have to understand context in children's cases, because children often articulate things differently. Or don't know the reasons that things have happened to them when they were children.
Can I just ask a quick follow-up on that?
Oh, and I didn't answer your question.
No, that's fine. You're welcome to come on. The issue of children, I mean, there's some moves now in the UK, which is part of the Convention on the Rights of the Child, obviously, to start thinking about ways in which that treaty might be used in terms of litigating refugee cases, and there's somebody who's doing a PhD on that at the moment. And you talked earlier on about the fact that human rights, bodies of human rights law, have had an influence on refugee status, jurisprudence developments in the US. Has the lack of ratification of the CRC by the US made children's cases take a different route, or is it simply the case of context? Once opened up, you're...
And it's under the Refugee Convention, and we signed the... We try to argue, from these human rights treaties, even though the U.S. doesn't take them very seriously as independent sources and enforceable norms. And you're right, the U.S., I mean, the U.S. has some good decisions in the asylum area, and, you know, is not as behind as some other countries, but it will not look to other countries. It never cites the jurisprudence of another country. I don't mean never, but, I mean, I'd be shocked if you did a search and found 5 cases, and they'd be federal circuit court decisions. So this complete lack of comity that the U.S. has in relation to other states' parties is very disturbing and unfortunate.
But the Supreme Court doesn't do that. For example, in Bowers and Hardy.
Well, the Supreme Court is starting. It's starting to recognize them. We had a case involving the persecution of others bar, in which we, before the Supreme Court, a case called Nabusi, in which we argued that other states parties to the Refugee Convention consider the defense of duress, and that's what we were arguing for, is that duress should count. And the Supreme Court said, you know, the decision of other states parties to the same convention should be given some weight, or something to that effect. So that was, I mean, we may be moving in some positive direction in that. Although I get scared every now and then because I hear the jurisprudence in other countries. That's so.
We'll see where that goes.
See where that goes.
Jenna, I know you must ask a question with a comment.
So a bit more internal location decisions.
Yes.
You were up?
No, what I was going to ask about is a slightly self-interested question, but you mentioned a couple of times working together with the psychologists. And so, standardly, the way, speaking as a psychologist, most of the work with psychologists here consists of asking for a medical legal report, getting a report, thank you very much, and then moving on with the legal case. And so you're sort of suggesting that you have...
No. That's not how we work with psychologists. So we get the report, we react to it, we suggest other areas that the psychologist may want to explore. We dialogue, so we may learn something that we didn't know before. And understand about the case, but it's a much more reciprocal relationship. But it's not just getting the report and giving it back, because people often hear things in different ways, and even our clients hear things in different ways, at different times in their lives.
And you mentioned
but there's inconsistency of facts, and so, you know, inconsistency is such a major factor for asylum seekers, and it's constant. Our clients are constantly changing their story. I mean, it just never is the same. And we take 6 months to develop a story, and 3 months or 4 months to develop. So it changes over time. If the psychologist happens to get a different version of the story than we got, it's a problem. So we really work together
Further questions, comments? Yes, Susan.
I'm also a lawyer, but the paranoia about terrorism, has that affected the refugee granting situation in the United States?
That's an exclusion cases or whatever.
Yeah, in cases where, you know, minor kinds of crimes can be considered a basis for exclusion, and terrorism is a bar to asylum, and material support of terrorism is a bar to asylum. And when we don't have a duress defense right now, we have situations where literally, you know, I didn't know that David was a terrorist, but I'm offering him a glass of water because his water is gone, and I've just materially supported terrorism. Even though I didn't know, and even though it was minor, and even though there's no statute of limits or anything, so that's where it really comes in. I'm thinking another way that it comes in is media. I mean, I think it's harder now than the days when we were developing the gender asylum, you know, guidelines and stuff, which is the early to mid 1990s. It was easier then than it probably is now. But one thing I remember, I mean, I feel very proud of what we did with the media, and I didn't have any particular background in how to deal with the media. We didn't take any course or workshop in it, but it was women reporters, and they told stories of individuals, compelling stories of individuals. Now maybe that wouldn't make things more favorable here in the UK. And yeah, it's different times now.
I think that's the case in the UK, although quite when the positive times were in there, it has had quite a long memory.
That's part of the long memory.
Talking of long memories, can I push you on the last point, which is where do you see the jurisprudential developments going, both in the gender field and if there are other areas where the US jurisprudence on asylum is starting to open up or take particularly interesting parts? I mean, you mentioned the whole gang membership
in gang
thing.
cases, in children's cases, I think unaccompanied children is like the hot issue in the U.S. now. I mean, everybody's getting funding to work with unaccompanied children, and so I think that's a big issue. I feel like we're not going to lose this. I mean, the gender asylum issue is really what it is a principled approach to interpretation of the refugee definition, right? And that's why to the extent that we win, we sort of win in other areas as well, because it's a principled and coherent approach to interpretation of the Refugee Convention. And I feel like, I don't want to predict, because I don't know if we're going to win or lose, but I don't think we can lose entirely, because I think this change has already occurred so deep in our decision-making culture that board is going to come out and say what it said in RA. This violence from this man is just because he's a crazy guy. You know, that was basically the reasoning in RA. So I can't say for sure how the regs are going to turn out, or how. I feel very uneasy at this moment, unless it goes through in legislation. But even there could be some tinkering with language that could be problematic. So I don't know.
And so just a very quick follow-up on that. Has it changed with the different administrations, from Democrats to Republicans, or do you get a fairly consistent line on these issues? And does that level of politics affect it at all, or is it fairly remote?
To some extent it affects it, yeah. I mean, during the Clinton years, we got some appointments to our Board of Immigration Appeals, which were really intelligent, progressive people. And that laid the work for the Kasinga decision and the DB decision, and a lot of those were, but I mean, appointments that were good appointments of decision making. And you know, Attorney General Ashcroft was terrible during the Bush years. And what they did was they cut the board in half. Said in order to make it more efficient, we're going to cut the decision makers in half, which was really a way to just fire all the progressive people that had been higher than in the Clinton years, right? Which is what happened. So it makes a difference, but some of these decisions, like a lot of the good decisions that I'm talking about, are being made by asylum officers, asylum officers, if we have a mean-spirited administration or a reactionary administration, asylum officer training materials could change, and gradually the culture of the immigration court could change, right?
So it's that kind of institutional change right now.
But we're having a lot of good changes that are happening by low-level decision makers who are not getting touched by higher-level people, and the higher-level people have been on hold on this issue. And meanwhile, this culture has developed at the ground level that is very interesting and promising in many ways.
So we've got another comment over there. Yes.
Hi, Deborah. You talked about international human rights law,
right.
And I was interested to know in what way you might use the CEDAW, the United Nations Women, because the UK is reporting to the CEDAW committee this summer, and I've been working with, I'm from Asylum Aid, and we've been working with other people in the women's sector, and we've realised that we are reporting alongside Afghanistan, Iran and DRC. So starting arguing that there's violence against women in the UK sort of pales into insignificance despite the problems here. And one of the arguments we want to put is that despite the Foreign Office here has got a very strong initiative on preventing sexual violence and conflict in countries like the DRC, but when women come from the DRC and claim asylum and talk about having been raped, they're disbelieved, they're refused asylum. So I was just interested in sort of...
Yeah, the treatment of refugee women in the country of asylum is certainly a really great issue to report to the CEDAW committee, right? I agree with you, and that feels like it's at a different level, right? It's just about, how all this violence is going on, and yet when people come and manage actually to flee it, even though there's so few of them, we turn them around. We have ridiculous rules on internal relocation, which we can barely explain to ourselves, but we just sort of throw the words out there and think that's sufficient. I think the whole critique of the way women's cases, and somebody told me, this was something I was going to, somebody told me, I'm not sure I understood her correctly, told me today that the UK only gives refugee status for 5 years and you have to remake your claim. That's got to violate something.
You don't have to remake your claim.
What?
You don't have to remake
You don't have to remake your claim, it just ends, and then what happens?
You extend your leave through immigration law.
You get extended, so you don't even get a chance to remake your claim.
Well,
you have to show that you're still at
the
risk.
point is that what used to happen is that you had indefinite leave to remain. Now you have 5 years leave to remain, and then you have what is called active review. So if you committed a criminal offence, then you're told, look, you need to remake your claim to say why you can't go back. Otherwise, you apply for what is then called indefinite leave to remain and then citizenship. So, you got the safeguard.
And I misunderstood.
You got the safeguard.
Yeah.
Well, there could be cessation or something like that. They could argue
but that's the actual
and say,
review.
see you. Doesn't matter that you've been here 5 years.
So once you have your refugee, is it refugee claim or asylum claim? I don't know how it's characterized.
Well, it's called refugee status.
Refugee status. Once you have your refugee status claim approved, unless things change in 5 years or something else,
or personal conduct issues,
or some personal conduct issue, you're going to be on a path of citizenship.
Yes, at this current stage.
Timmy told me something, I misunderstood it. Okay, I'm very glad I got that clarified. Thank you.
Well, you've heard it here. Any further questions or comments? Well, I think we've touched on a very wide range of issues, and I think for us in the UK particularly, it's quite easy to be blinkered and focus on the kinds of developments which are happening here. And having this sort of comparative exposition is really very useful, and also very interesting to hear how this particularly interesting area of asylum jurisprudence has been developing. So I'm sure you'll want to thank me in showing our appreciation to Deborah. Thank you.